So without further ado, I would like to welcome the first moderator, Anja Blaj from the blockchain think tank Slovenia, to introduce us the panel.
So welcome and thank you for joining us on this wonderful afternoon, Friday afternoon. I'm pretty sure that you all are waiting for this weekend ahead of us, but before we enter into the weekend mode, we have a very important task or a very important topic to address, and that is the MiCA regulation. So the regulation on the crypto markets and, of course, the Crypto Assets Act. My name is Anja Blaj. I'm the president of Blockchain Think Tank Slovenia. This is an organization that takes care of connecting the regulators of Slovenia with the representatives of blockchain industry. And today it's my pleasure to have a panel of great experts with me. There's 3 in person, and then the rest are with me on the Zoom. So to go through the names and to actually express who's with us today, we have Mr. Rok Žvelc from European Commission, Directorate General for Financial Stability, Financial Services and Capital Markets Union. We have Ms. Klara Rozman, who's the representative of the Ministry of Finance for Slovenia. We also have Mr. Jeff Bandman, who's the expert panel of the European Blockchain Observatory Forum, Bandman Advisors. And we have Mr. Mark Taverner from Inatba. Then we have Mr. Paul Worthington, who's the Public Policy Manager at Facebook Financial Europe at Facebook. We also have Mr. Florian Glatz, from the Bundesblock and representative of the European Crypto Initiative. And of course we have Ms. Marina Markezic, who is also on the board for Blockchain Think Tank Slovenia and also a representative of the European Commission Initiative. So to kick us off and to actually open up the discussion, we're going to start with Mr. Rok Žvelc, who's going to introduce us to the EU Commission perspective on MiCA regulation and surely invite us to understand better the initiating motivations for the MiCA regulation and overarching process. So I'll leave the word to you.
I work in the digital finance unit of the European Commission, DG FISMA, so it's the Department for Financial Stability and Financial Services. And what I'm going to do in next 10 minutes is actually to present what are the motivations for the European Commission to propose 2 proposals on crypto assets. Where are we coming from? That it didn't happen over the night, but that it has certain history. And then also to outline the main elements of MiCA and also another act that accompanies it, so that all participants are informed what we are going to talk about today. But just allow me to share a very short presentation. So in terms of the motivation for these proposals, the crypto assets, you know, they have quite some history already, more than a decade by the emergence of the Bitcoin. But most of the time, the European institutions were monitoring these crypto assets markets and also issuing the warnings to investors that they need to be careful, that it's highly volatile, that it's not protected, and so on. So we have the warnings of European supervisory authorities from 2018 and also 2021, it was reiterated. But in 2018, the European Commission prepared a fintech action plan, which mandated the European supervisory authorities to assess to what extent the crypto assets are already covered by the existing legislation. And if so, whether this legislation is fit, it's appropriate for this purpose of regulating these innovative assets. And second question was, the second question was, how could we address these risks? So the ESAs came back with the advice, with the report, saying that some crypto assets are already covered by the existing legislations. They can be e-money or financial instruments if there are, for example, participatory rights, which needs to be determined on a case-by-case basis. But this legislation has not been written with this new class of assets in mind. So it is possible that there are gaps and there are certain provisions that may hamper the development of these technologies. But most of the crypto assets, they are not covered by the existing legislation, although they may exhibit similar risks to financial instruments. for financial stability, for investor protection, and for the market integrity. So they have kind of advised that we should assess whether a regulatory framework is needed. And then there was another factor which is very important. In 2019, there was a stable coin announced that could become a global one. And then the whole international community was grappling with the question how to regulate these new stable coins that could become global in nature. There were discussions in G8, G20, the report were produced, also the high-level recommendations in the G20 framework. And this also influenced our thinking of how to develop the regulatory framework. And then in 2020, September, we presented a digital finance package that entails digital finance strategy, a proposal on cybersecurity, but also 2 proposals on crypto assets. And the first one is the MiCA regulation that I will present a little bit more in detail, but it should not be forgotten that we have another act which is very important, and it addresses the issue that, this technology can have very high potential for trading and settling financial instruments, tokenized financial instruments. So this is important. It's about crypto assets that are already covered by financial services legislation, and it's actually about experimental regime that would enable market participants to test the technology in the area of trading and post-trading of transferable securities. And based on this experiment, we would get evidence, and then it would inform our future policy development and legislative developments. We could continue with this pilot in 5 years, or we could make targeted amendments to the financial services legislation to enable the development of this technology. So it's a very important act, but it's different than MiCA, because MiCA, it's about regulating crypto assets that are not covered by the existing financial legislation, including addressing the issue of stable coins. It regulates the issuing phase of the issuers of crypto assets and also crypto asset service providers. Just a few main elements of what we are actually regulating by the MiCA. We are regulating 3 categories of crypto assets that are not covered by the existing legislation. 2 of them on the right-hand side, you see, are stable coins. E-money tokens are, for example, crypto assets that stabilize their value, their reference to a single official currency. It can be US dollar or euro or any other currency. And the second category are asset reference tokens, and they stabilize their value vis-a-vis a basket of currencies, commodities, other crypto assets, or combination of those. So it's a basket of assets. And then the third category, it's a residual one. It's all what is not covered by the stable coins. It falls under the other crypto assets. It's a kind of catch-all category, residual one, because we wanted to be comprehensive that everything what is not covered is now regulated with the MiCA. And then considering to which category, to which basket the crypto assets fall that are issued, then we attach different obligations. The most light touch requirements are for other crypto assets. So for these residual categories, which is more about disclosure and transparency, lots of requirements on the production of the white paper, on the marketing communication. The issuers need to act in a fair manner vis-a-vis holders of these coins and who will buy them, and so on. There are also some requirements on liability, on right of withdrawal from the offer, and so on. But these are more light touch requirements for other crypto assets, whereas for asset reference tokens, the requirements are much more robust. First of all, you need to get a license in the EU and you need to be established in the EU. And then you have lots of prudential organization and conduct of business requirements. For example, you need to have own assets to operate. Then organizational are, for example, that the managers need to be fit and proper. Also the shareholders, big shareholders need to be fit and proper, and so on. And then what is also important is the set of requirements that refer to the reserve of assets. So they need to establish a reserve of assets. And there are lots of requirements on transparency of reserve of assets, on transparency regarding the redemption rights, and then on the custody of the reserve of assets and investment of the reserve of assets. And then as regards the e-money tokens, the requirements are even more robust. We actually use the regime that is currently applicable for e-money institutions. And they can be issued only by e-money institutions and credit institutions. And what is also important is there is an obligation on redemption at par. So if you buy token for €1, you can get it back for €1. And there needs to be also a reserve of assets that is fully backed. So there are much more robust requirements also for e-money tokens. And then when we come to crypto asset service providers, again, there is an authorization requirements, prudential, organizational, and conduct of business requirements. And then there are specific requirements that we borrowed from the MiFID. So this is the legislation that regulates the investment firms services with regard to classical financial instruments. So we borrowed also those requirements to regulate crypto asset service providers. Just to further things, it's supervision. So there is also a lot of provision on the supervision. And in case these stable coins become very big projects, there are certain criteria for this. They are called significant asset reference tokens or e-money tokens. And the supervision here is actually then shifts to the European Union, to the European Banking Authority under the Commission proposal. And there are also some important provisions on market abuse, market manipulation, and inside trading that are also important in this context. So this is really an outline that you know what actually we are regulating with MiCA. We are regulating the issuers of crypto assets that are not covered by the existing legislation, including stable coins and also crypto asset service providers like custody, trading platforms, and so on. And then just final thoughts on the way forward. This is the Commission proposal, so it needs to be adopted by the co-legislators, the Council and the European Parliament. And the DLT pilot that I presented before, which is an experimental regime, is currently entering the trialogue phase. So we expect that it could be adopted by the end of the year. MiCA is lagging a little bit behind, so we expect that it could be adopted next year, already early next year. Thank you very much, and I'm happy to reply to any questions that you may have.
Thank you, Mr. Žvelc. That was a very comprehensive and detailed overview of what MiCA represents. And talking about the negotiation and the preparatory work regarding MiCA as the act, the regulation coming from European Union, we are going to be turning to Ms. Klára Rozman and ask her more about what is the role of Slovenia now presiding the Council of European Union, and further on, how does the process, or what is the role of Slovenia looking like when we are negotiating these rules, when we are talking, cooperating between different countries. Maybe you might also lead us through a high-level overview of just how the process looks like and which states are actually having their opinions.
I would like to thank the host for the invitation and also thank the Commission for sharing their explanation. The main role of the presidency is to ensure the continuity of the legislative procedures during the following months. As presidency, we coordinate negotiations among member states on EU legislation. Every stage of the process of legislative files, the presidency chairs the meetings. That means that presidency leads the meetings, prepare working papers, makes conclusions, prepare agenda. The advantage of being presidency is an ability to prioritize the legislative proposals of the Commission. As Slovenian presidency, we chose MiCA as one of our priorities, but presidency needs to follow the neutral role. that means that presidency acts as honest broker while coordinating negotiations among member states. In the role of presidency, we can propose possible solutions regarding the content of the legislation. This is called a draft proposal in order to reach the compromise. But the positions of the member states on the presidency proposal can be sought out through the non-objective procedure, and if it's not broken, presidency can continue with their proposal to the next level, the trialogue, as was already mentioned. Regarding the states where they can provide opinions, I would say that member states provide their views while examining the Commission proposal at the Council working groups and at bilateral meetings with Presidency. Member States collaborates with its stakeholders such as ministries, bodies within ministries, national competent authorities, industry, banks, and etc. When the general approach will be reached among all member states, the procedure goes to next level, the trialogue, where presidency presents all the 27 member states.
Thank you very much for that. We will definitely come back to you with more questions. And after Ms. Roseman, we're now turning our attention to Mr. Jeff Bandman to tell us more about the role of European Blockchain Observatory Forum, how it came to be, what, for example, the European Blockchain Forum also thinks about the MiCA regulation, and whether you have a designated working group to focus on that work.
Great. Good day, everybody. And there. Okay, great. Can people see the screen and see me? Wonderful. Thanks. Yeah. So I'm going to cover a few points. I'm going to just review briefly some of the what the EU Blockchain Observatory and Forum does and some of the work in this area, and then I'm going to introduce some of my own perspectives on both kind of the benefits of MiCA, which I think there's very broad support for the importance of, some developments that have been addressed, and some things that I think may still be open question marks or left to the member states. So a bit about me. I'm an expert member of the EU Blockchain Observatory and Forum. I'm a former regulator in the US, where I was a senior official at the Commodity Futures Trading Commission. We first recognized virtual currencies as a commodity under the US statutory definition. And therefore, we set up a task force in 2015 to start monitoring this, and started working with regulators in the US and internationally. Now, that in itself actually identifies one of the gaps that MiCA is now filling, which is that in the US, the regulatory approach has really been to apply existing frameworks and laws. And so you hear a lot about the SEC or the CFTC, which apply existing definitions of securities and commodities. In Europe, the definition of commodity did not at the time include intangible assets of the nature of crypto assets that are addressed under MiCA. So it's very important now to have a comprehensive action. I'm also, in addition to my work on the EU Blockchain Observatory, I've joined the ESMA Consultative Working Group and affiliated with UNIC, which is helping to operate the EU Blockchain Observatory and Forum, and have been active in the Global Digital Finance Policy Initiative, which I co-founded, which has also been very active in this space. The EU Blockchain Observatory and Forum It's a European Commission initiative supported by the Commission to accelerate blockchain innovation and development of the blockchain ecosystem within the EU. You know, it's a bit of a supportive policy think tank. It was actually created as a European Parliament pilot project. So, you know, I think it's great. You know, we really don't have anything equivalent in the US, just by comparison, you know, where it's, you know, essentially something that was conceived of by Congress and then operated by and on behalf of the executive branch. And so this is actually the second edition of the Observatory. And I think also the fact that it doesn't get too entrenched and that it rotates is one of the really exciting things about it. So I'm part of sort of the second wave of experts that are assisting the work. And currently this is being led by Intrasoft, the University of Nicosia, and the other entities shown on the screen here. So the Blockchain Observatory has certainly treated MiCA as very important. You know, after the legislation was proposed, and as you know, thanks much for the introduction and current recap. So we had a workshop and a report that were put out in January. I'll show you links to where you can see that information in a couple of slides. You know, so the program that we had, we were initially welcomed by Pateras Silgavis, who I understand has just changed roles and moved from DG Connect to become a judge on the European Court of Justice. So congratulations to Pateras. That should be exciting. And maybe there will be some digital asset cases that come to them. And then we also had the DG FISMA and other regulators, and then ourselves in Inatba, who I think I believe Mark is speaking a little bit later, you know, raised some of the questions. I think some of the issues that we raised, oh, and here's where the report and the recording are available. And I think, and then the Blockchain Observatory and Forum continues to produce monthly trend reports where we're monitoring this. We've also been doing some workshops. We did a roundtable on NFTs, and that report should be coming out shortly. We also have one on DeFi. So really active, and it's a kind of a, you know, really, you know, a large, diverse group of experts with a lot of perspectives, really trying to help just promote, you know, without an agenda as such, but really to help think through the issues as a kind of a think tank here. So now I'm going to spend a couple of minutes, and I would say these are, you know, my views, certainly informed by the work of the Blockchain Observatory and Forum, but we don't really have a mechanism in this context to say these are the official talking points. But, you know, these insights or perspectives, I think, you know, evolve from that work. So first, I think, you know, even when we're going to talk about things that could be, you know, improved, you know, I think that there were, oops, this goes on the next slide. So I think that the most important thing is it really is enormously beneficial to have this comprehensive regulatory proposal with passporting across the union and doing it in contact with the DLT pilot and with the other provisions around cybersecurity. You know, it's timely, it's comprehensive, it's highly needed. You know, I think that there's a recognition that there were, you know, very significant gaps where, you know, some of these novel assets, they didn't quite fit under the definition of a commodity. They also didn't fall within the MiFID definition of a financial instrument. You know, member states, you know, I think took action to varying degrees to innovate and put regimes in there. You know, I was a bit of a fan of the PACT regime in France, which I thought was very innovative. But you know, different jurisdictions have, but, you know, clearly, you know, for businesses, for individuals in the union, for regulators, for regulatory convergence, and having a comprehensive legislative and regulatory proposal is going to be extremely valuable to have this proceed to provide regulatory certainty and to have things on a solid footing. In the US, you know, there's been plenty of innovation, but, you know, there has not been any comprehensive, really administrative or legislative action. So what's happening is that regulators have been applying their existing frameworks kind of within their lanes. Then whenever you have kind of a change of who the boss is, you get a new interpretation or a set of new interpretations, which can, you don't have the degree of consistency. It has left some room to to our states to innovate. So New York is actually one of the largest supervisors of crypto asset businesses in the world. Wyoming has innovated on property, on how you can have bailments and security interests under our commercial code. So there's scope for that, but having comprehensive legislative proposal is very valuable. I think that there were a couple of challenges with the initial MiCA proposal that, fortunately, the legislative process, even before the trilogue process begins, have been addressed. A number of these had to do with some of the triggers and threshold levels around when you would need to have a prospectus or white paper and what their review levels were. One of my biggest concerns, which we talked about in UBOF in the earlier roundtable, had to do with some of the provisions that I at least considered deeply flawed for if a licensed European credit union were to be the issuer of a stable coin, so either an e-money token or asset reference token or a significant one. I agree, and this was something that was pointed out by Mr. Sissons, that they shouldn't have to go and get a whole new license, but they were exempted from a lot of the other requirements that a non-credit institution issuer of a stablecoin would have. And the concern was really that credit institutions have experience and resiliency in many areas, but in terms of issuing digital assets, protecting them from a cyber perspective, operating a stability mechanism is really outside. I mean, it's outside most people's competency because it's so new, but it's certainly, there's no demonstrated competency of existing credit institutions. And, the feeling was that they should really demonstrate or develop that competency and that you could, in fact, have contagion and harm from credit institutions, which are so fundamental to the daily, everyday lives, and you could actually have a harmful effect on financial stability. But my understanding is that those concerns, which were probably my biggest concerns, have been very much taken to heart and addressed. And I think that there's a pretty broad consensus that a lot of things have been addressed and have been approved through the legislative process. Second, I want to mention, having said, and I hope clearly communicated, what I see as enormous benefits from having a comprehensive legislative proposal in place. I think that there are a couple of curveballs that have emerged, and also some things that maybe just aren't covered, and maybe MiCA is not the place to cover them, and they will be covered in further work. One of them, and a lot of people who watch this space closely, including me, we were very surprised a couple months ago when El Salvador actually declared Bitcoin to be legal tender, and then subsequently rolled out a program providing Bitcoin to its citizens. So, my purpose in bringing that up today is not to get into the question of whether that is a good policy or not. Clearly, within the EU, the digital euro is a project that is, at the highest policy level being addressed by the European Central Bank. It's being explored and tested by, a number of the central banks across the union. But, so there was a definition or a number of definitions of, sort of what was or was not, things that were outside the scope of MiCA were things that were, I think there was a previous formulation, which I think was legal tender. And then because, for technical reasons, often legal tender is defined as bills and notes. And so something that's electronic or digital is not necessarily, legal tender. But now we have official currency of a country as sort of what I think where the working party got to on that definition. So now we have this issue where in El Salvador, Bitcoin is, as I understand it, legal tender, and it is, as I understand it, official currency of a country. So, clearly, it's not the intent of of MiCA to exclude Bitcoin from the scope of the legislation. I mean, that seems to be front and center of among the digital assets that are in mind. But I think that that's going to have to looked at a technical level, and that this has come up. I've been working with the Republic of Cyprus on its blockchain legislation, and so in that context, where certain definitions kind of mirror those in MiCA, and that legislation was put out for public consultation, earlier this month. I think a number of people need to think about how are we going to address, and what if it's not just El Salvador? Now, clearly, we do not have the issue, that no country that's part of the Eurozone can declare anything other than the euro its official country or create some alternate central bank digital currency. But so that definition and formulation need to be refined. Couple of other points. I think that NFTs are a large group of crypto assets that have become non-fungible tokens. We've been looking at them, from a number of perspectives in the EU Blockchain Observatory and Forum, and that report should be coming out soon. It's not clear to me how they fall under any of the token definitions under MiCA, or whether that was really the priority. It's also not clear to me that really needs to be addressed today. I mean, I think that NFTs as a unit, are not financial. They're not financial instruments. They could be organized into an investment vehicle if somebody set up a fund and said, "Hey, send me all your money and I'll, invest profitably in NFTs." But then you've got, a financial undertaking that's regulated some other way. So it may not be urgent to address that, but maybe that'll come up subsequently. Also, DeFi has really skyrocketed in the last year, and what is the legal status of DeFi governance tokens, and are those implicated or should be? So I think again, I think that this official currency definition may need to be solved. I think it's a technical matter, because I think from a policy matter, people think they know what was intended. So we'll get there. I'm not sure it's urgent to do the NFTs and DeFi definitions now. Those can perhaps evolve a bit more, or perhaps can be handled in the kind of secondary legislation standard. Another area where I think it's just important has to do with the intersection between GDPR privacy requirements and rights, and how those intersect with the blockchain. What I've seen is that some of the national privacy authorities have been very thoughtful and put out their interpretation. CNIL in France, I think, has actually been quite a leader in some of its thought pieces, and I assign their analyses on that in the courses that I teach. And then something that I think would just be helpful, but maybe we get to that in any evolution of EIDAS, is definitions of official signatures, e-signatures, enhanced signature seals, and there's different levels of those, and to sort of apply those to how to conduct commerce using crypto asset tokens and stablecoins, so that when a person or legal entity signs those, we know how to kind of fit those into that framework. That would be useful. Then I think that there are certain things that MiCA just will leave to the member states. Kind of the legal status of blockchains or of evidence from blockchains. That's something that we looked at in the Cyprus legislation that I mentioned. And, I think that other jurisdictions are starting to turn to these. Are crypto assets property? And if so, exactly what type of property, and how can property rights be exercised? These are things that I believe are more typically left to the kind of member states, but, kind of security interests that relate to things that are across the capital markets union, could be relevant. So having clarity on that could be, again, something that benefits commerce in these things. And then another thing that MiCA leaves to the member states, at least for now, and maybe under AMLD 6 or AMLR, but the supervision or licensing of VASPs under FATF rules until the MiCA enters into force. So in closing, I'd just like to say, I think that although I've mentioned, I think, some gaps or areas for further work, I think that this is, incredibly important, comprehensive legislation, and very excited to see as we go through the completion of this process in trilogue, whether later this year or under the French presidency. Very much look forward to seeing this all take place. So, thank you very much for giving me the opportunity to exchange views here, and I look forward to hearing my further panelists and then taking questions as we proceed with this afternoon's panel. Thank you.
Thank you, Mr. Banman. That was a lot of concerns. We definitely look forward to your report, both on the NFTs and DeFi, definitely. And talking about the concerns, we do have with us Mr. Paul Worthington, who represents Facebook and Libra. First off, we need to make a distinction between those two and who it is that you represent. And then afterwards, I look forward to hear your concerns as well. Or perhaps what do you think about MiCA benefiting the states, benefiting the clarity in the crypto ecosystem? And perhaps you can also give us an overview of what you think, since Facebook is present on basically each continent. So you, as a transnational company, might actually have a very good perspective on what happens in Asia, what happens in the US, and whether the MiCA and the EU regulation differs from all of those.
Yeah, sure. And hi, good afternoon, everyone. Thanks for having me at this great and timely event. I'm really looking forward to discussing the future of crypto assets this afternoon with you all. So yeah, let me take those each in turn, if that's okay with you. So first of all, why does Facebook care about this space and think it's so important for the future of the EU's digital finance ecosystem? Well, at Facebook, we've built Novi, which we regard as a next generation digital wallet. This will allow people to pay one another either for domestic or cross-border transactions using assets like stablecoins that will enable them to leverage new infrastructure, which is interoperable, cheaper to use, and secure, built on top of the DM network using the DM stablecoin. So let me clarify a couple of points up front here, which is that they represent, as mentioned, rather than the DM Association, which is an independent member association of which we are one member of, courtesy of our digital wallet, Novi. So DM is the new name for Libra, which you might have previously known the project as. DM is made up of 26 members alongside other companies and social impact partners. The association has built a new network for payments. On top of that, they are seeking to launch a first stablecoin, the DM dollar, and will be backed one-to-one with high quality assets. The DM dollar will run on top of the DM blockchain, the first purpose-built payments blockchain. So what does this mean for consumers in the EU and around the world? Well, Novi will provide consumers with an easier and cheaper way to send money internationally, cutting the time it takes to send money, reducing the cost involved, recognizing the current global average cost of sending remittances is still about 6.5%, way above the UN Sustainable Development Goal of 3%. So anyone with access to a smartphone would essentially be able to access Novi, providing that we have the regulatory approval to operate in that market. And they would be able to send and receive the money using these new payment rails. And our business model would be one where it's focused on the merchant side for merchant services. So our desire and goal on the consumer side is to be able to offer those payments for free, essentially. Now, our goal has been to build something that included new infrastructure, which internally and we regard as almost a protocol for money on the internet. The analogy we use is thinking about the cost of communications and how the cost of calls or sending text messages has dramatically reduced with the advent of the internet and different apps and services that sit on top of that. Some of those might even be from ourselves here at Facebook. We feel there is now an opportunity to try and replicate this trend for sending money. And that's why we're really excited about Novi, but we're also why we're really excited about the potential of MiCA in the EU context as well. In the EU, we also believe there's still a long way to go to improve the way in which money moves. So if you look at the latest research from Eurostat, for example, 45% of all EU personal remittances in 2019 were sent outside the EU to other countries in other regions around the world, where the costs are generally higher than transfers within the EU. How much did that actually account to, though? Well, the total amount of remittances sent in 2019 was 53 billion euros. So if you're thinking about the potential for saving and fees on that amount of money, you know, we're not talking an inconsequential amount of money here. The opportunity we see in this area is the potential for utilizing new payment rails built on blockchain technology, which is one of the reasons why we are supportive of the aims behind the proposed MiCA regulation, because we see it as a key enabler for the future of the EU's digital finance ecosystem, of which Novi would be just one constituent part of it. So turning to MiCA specifically now, and then putting it in the broader context of the work that we do around the world in our wider policy conversations concerning crypto assets. Firstly, I want to say actually that today feels a really good day to be discussing MiCA in the broader context of the Commission's digital finance package, which was actually published exactly 1 year ago to the day. The reason I know the exact date is not because I'm a massive policy geek and have these dates lodged in my mind. It's actually because it coincided with my birthday, which made for a really busy policy-filled day last year, but it also means I'll never forget the day MiCA is published. Look, taking it to a bit more serious for a second, when we think about the regulatory frameworks for crypto assets around the world, I think as a first principle, it's really important to understand and assess the intention behind what a piece of legislation or regulation is trying to achieve, which is why I mentioned the broader digital finance package, because you need to look at the objectives that underpin what actually the EU is trying to achieve. So we support the broader goals contained within the digital finance package, specifically that the future of finance is digital, as set out by the Commission, and the accelerated trends towards digitization highlight the importance of creating a regulatory environment in the EU that is pro-innovation, safe and reliable for consumers. I'd actually also add here flexibility to this list as well, because a flexible regulatory framework is important to ensure MiCA has the ability to adapt to what is still a nascent industry and sector where innovation in business models and products is occurring at pace. A framework which is overly prescriptive now and today will really curtail the ability of firms to innovate and potentially put them at a disadvantage due to limits on how they could grow and evolve over time in the EU. The reason I highlight the importance of objectives and principles is because they are crucial in framing the policy debate itself. If you don't have an appreciation of the end goal you're trying to achieve, I think in our experience, we find it's much easier to get lost in some of the weeds and the details of the requirements of various different articles, etc. So, you know, as a reminder, I think it's useful to put into context what the actual 4 general objectives of MiCA are. So 1 is legal certainty, 2 is supporting innovation, 3 is instilling appropriate levels of consumer and investor protection, and then 4 is ensuring financial stability. I mention these because in some policy discussions, it's easy to jump straight into the very technical areas without asking, is what we're talking about in line with the objectives, and how is it going to create a framework that meets everything the EU is trying to achieve at this moment in time? And also, these are not conflicting objectives either. They're actually related objectives, is the way it's described in the text. In my mind, that means you need to be cognizant of each of those objectives when reflecting the merits of certain provisions. Well, what does that mean? Well, for example, how do you promote innovation as an objective and ensure financial stability at the same time? These are not conflicting objectives. We need to find a framework that actually promotes both at the same time and not putting one objective at a disadvantage. These aren't easy questions, though, obviously, but ultimately, when you look at different regulatory approaches emerging around the world for crypto assets, ultimately, it does come back to what are the policy objectives that policymakers are seeking to achieve with their action. So let's just take the UK as an example, where I'm based. The approach there is much narrower than MiCA, with the UK currently consulting on a specific regime specifically for stablecoins, as opposed to other types of crypto assets. They've left the door open for that in the future, but it's not what they want to address right now. As a global industry, this does raise some interesting questions, particularly for policymakers and their collaborative efforts when designing regulatory frameworks for crypto in terms of what is captured in scope and what is not, and how that then creates potential patchwork frameworks around the world. That said, I think in our experience as well, we do see a lot of crossover between policy efforts in terms of the different regulatory questions they're seeking to answer. And in the case with Novi, for instance, One of those has been about the way in which a stablecoin ecosystem functions and the different role and responsibilities of, say, the issuers and different wallet providers. So MiCA introduces some new innovations into financial services regulation, and in particular from our perspective around the way in which digital wallets operate and are supervised, which builds on the foundation of regulatory principles first outlined in the e-money directive for e-money institutions. There are, though, some really important distinctions between the role of wallet providers and issuers in an e-money context compared to MiCA. And for that reason, we think it's really important that MiCA sets out really clear definitions, both in terms of the roles played by the different regulated actors, but also for the different categorization of tokens captured by MiCA. There's been a lot of discussion around the way in which different tokens are categorized and what this means for the regulation. But ultimately, we do need clarity here for it to be workable from an industry perspective. I'm just going to end by saying that I think from our vantage point at Facebook, if MiCA can set out a clear interrelated set of objectives that both supports innovation while also ensuring that consumer protection lens, but also providing the clarity around the different roles of the regulated actors in the ecosystem and the different kinds of digital assets are defined and treated, MiCA could be a really powerful enabler in this space across the EU. Now, that's obviously quite a complex set of objectives to achieve, but I think we're on the way to doing it. And I think discussions like today can only help us get there quicker. So with that, I'll hand back and happy to answer any questions later. Thank you.
Thank you, Mr. Worngton, especially for the positive remark made at the end. Very glad to hear that as well about MiCA regulation. And thank you for providing a bit of an international aspect as well. Now turning to Mr. Mark Tavener, who also represents the International Association for Trusted Blockchain Applications, known as Inatba. We might actually ask you about your modus operandi and how you came together, what it is that you do in Inatba, and especially what is your perspective on the MiCA regulation?
Well, hello everybody. Thank you for having us here. I was just thinking, as the wonderful speakers before me were talking, about how exactly a year on, you're absolutely right, Paul, here we are sitting on a stage with 8 people wanting to talk about regulation of crypto. I think a year and a half ago, if you asked 8 people to talk about regulation in crypto, you probably would have struggled because nobody wanted to address the topic. But here we are. So I work for Inatba. We're an international trade association focused on blockchain. We've got approximately 170 members in about 36 countries around the world. And we looked at MiCA, in fact, we looked at the digital finance package as, in total, as a really, really well-received piece of work. I must admit that when we first started reading MiCA and the pilot regime, and to a certain extent DORA, some of our members got a little concerned because it takes a while to understand the language. You know, of particular concern were certain requirements in there around legal entities, which of course presents an existential threat for DeFi, and Europe certainly doesn't want to scare away innovators. And there were certain other topics as well to do with level playing field, technology neutrality. But by and large, I think what we found as we've worked through this now is that the Commission, Parliament, and the whole ecosystem working on this have really been quite open-minded. Open to learning, open to receiving evidence, even open to, through negotiations, changing the text in places, as Paul alluded to. So frankly, it's been quite an enjoyable process in my role as leading Inatba, with a lot of members coming from the crypto space, the DeFi space, and generally the finance space. I thought this was going to be a very hard year, but it's actually been quite enjoyable. However, having said all of that, there are still certain areas that we need to focus on. And I'm going to abbreviate a lot of what I was planning to say because the speakers before me have spoken so eloquently. We're in very, very strong agreement, clearly, with everything coming out of the Observatory and Forum, as we as Inatba work very closely with them. But Paul spoke super eloquently about the need to focus on principles, broad policies, and big objectives. So let me just highlight, instead of talking super positively, perhaps let me highlight some of the areas that we as Inatba, on behalf of our members, think warrant some further investigation. Within MiCA, there is a certain stipulation that already licensed actors in the field don't need to prove their ability to run as crypto asset service providers, for example, whilst new market entrants do. They need to gain licensing, they need to prove their ability, they need to prove that their systems, their knowledge, their governance structures, and their people are fit to run these services. And we think that particular topic could use a little bit of work. And the analogy I want to give you here is, if I were to tell you that I was a pilot and you were entering my plane and I'm standing at the front of the cabin in the good old days when we used to travel, and you looked at me, yeah, Mark's the pilot, you sat down in your seat, you were assured that you were going to have a safe journey, and we were on an Airbus 380, so a double-decker with thousands of people in it, but you didn't qualify with me that I was actually a pilot for a propeller two-prop plane that carries 4 people, you might not have the same level of surety, confidence, and protection that you would hope you would have from, say, a national carrier, because I've told you I'm a pilot. So I want to draw the parallel there with crypto asset service providers, and in particular a point that Jeff made, which is this area it's quite unique. It requires certain skills, and I do think there should be a requirement for existing licensed players to at least reach a certain level of competencies, of systems, of safeguards, of governance structures, so that they can demonstrate that they have the ability to provide services in the realm of crypto assets with the type of responsibility and safeguards that the public should learn to accept from them. So that's the first area that I think, still requires a little bit of discussion, a little bit of debate. The second area that we're focused on is one of technology neutrality. So we've noted within MiCA that there is a limit placed on projects that don't issue white papers of €1 million. This is the ability to raise capital. So you can raise capital up to €1 million, for example, without issuing a white paper, which is great, because that means that innovators can get busy raising seed funding their activities, innovating, and learning what they don't know. It's wonderful. But if you look at similar technology platforms which are not blockchain, at the moment they're able to raise up to €8 million. And that doesn't exactly provide the type of technology neutrality, back to Paul's point, as a principle that we hope would be adhered to within the European Union, within the Commission, and certainly across this market of 27 countries. And then the final point that I would like to draw attention to is that, and I go back to the point I made about DeFi, Europe has a rich history of innovation. Earlier today, I was just trying to reflect on some of the most innovative moments that we gave birth to here in Europe. And I fell upon Gutenberg and the invention of the printing press in around the mid-1400s, and how that democratized access to information. It improved the literacy levels, not just across Europe, but across the world. And it took all of that knowledge that used to be locked up in big libraries of the wealthy families, the wealthy institutions, the wealthy industries, and it allowed the general population to start to have access to it on an industrial scale. So with this rich heritage of innovation, this fearlessness of supporting innovation in Europe, I do think that there is some room to look to this incredibly innovative decentralized finance market, decentralized autonomous organizations, and non-fungible tokens that were mentioned a few times, and maybe understand that, yes, perhaps MiCA isn't the right place for it. But to talk about the broader Digital Finance Act and to draw a little bit on the pilot regime, which probably isn't the right place for it either, maybe there is a space to carve out a sandbox or a safe, innovative space with parameters where Europe can play a home to foster innovation, to drive these entrepreneurs towards achieving great things within the parameters of defined risk, and bring together the private sector to share learning with the public sector, with the regulators, with parliamentarians, with governments, whilst learning at the same time how these public entities think and what constraints they would like to place on the private sector to protect the citizens, at the same time learning from the private sector just what the art of the possible is. And maybe this is the utopian dream that I'll begin to finish on. Maybe we could imagine a different way of regulating, perhaps, where the technology plays a more fundamental part, rather than taking regulatory constructs that were developed over perhaps 50 or 60 years and trying to retrofit those on top of technologies which, as we know, with MiCA only having been launched a year ago and DeFi not really being that spoken about a year ago, these technologies in 12 months can move at a pace that not only provide innovation to the private sector, but could yield wonderful innovative opportunities for governments and regulators. So to close off, just a general call out to colleagues in Parliament, in governments, in the Commission and across the industry. Inatba has already published a draft white paper calling for the establishment of this safe, innovative space for DAOs, DeFi and NFT projects, and we'd welcome anybody who would like to come and join us to discuss how we can provide evidence, collaborate and work together to make sure that Europe is the place where innovation in this sector happens, as opposed to perhaps being the place that we all remember as being so full of promise, but sadly overtaken by perhaps the Chinese or others.
Thank you for that. I love the analogy with the pilot. And talking about that, I do believe that you're going to enjoy the last two panelists that we have. First, I'll give the floor to Mr. Florian Glatz. Apart from European Union crypto initiative, which actually came to be just because of what you addressed right now, it has been around because there is a lack of representation for all the decentralized projects. It's pretty obvious that those don't have vocal points, or that they don't actually have the possibilities, the channels open to talk to the regulators directly, and the space is opening more and more. So we're definitely going to be addressing that. But before we dive into that, I definitely want to hear more about the German Bundesblock. So previously, Mr. Taverner said that 2 years ago or a year ago, nobody wanted to speak about the regulation, but it hasn't been that type of a situation when it came to Germany. I think that Inatba, not Inatba, but BaFin and German regulators have been very active in this space from before, not only a year ago. So I'm really curious about your perspective, Mr. Glatz. What has been happening? How do you see that? What is the role of Bundesblock there?
Thank you very much. I'm so happy to be part of this round here and be able to discuss, and enjoyed all the insights shared so far. To respond to your question, Germany has indeed been very active in terms of regulating the crypto finance space exclusively. Really, there is not much other regulation, if any, around other things than financial applications of blockchain technology in Germany. And it started in 2013 with BaFin categorizing Bitcoin as a financial instrument, which had a huge impact on the development of the space in Germany, since, for example, we don't have like Bitcoin ATMs in Germany like they do in Austria or Switzerland. It continued then actually in 2018 around the ICO hype, where Germany issued some guidance, BaFin issued some guidance around the nature of tokens. Essentially, they said that tokens could be securities, but this is determined by, of course, the MiFID II regulation. You could say that this was maybe too little too late. In fact, Germany kind of missed the opportunity in 2016 to 2018 to actually be the kind of the home of the corporate headquarters of most of the projects that were fundraising in this innovative way. Germany pioneered a blockchain strategy in 2019, which contains this infamous statement that Germany is going to engage on the European level to prevent stable coins, which, looking back at this in 2021, with the background of what's been happening in particular in the past year in the decentralized finance space, it just becomes clear how tragic that I think initial reaction to the emergence of the idea of stablecoins back in the days when this was drafted actually is nowadays. And I think Germany will have to change course on this particular stance. In 2020, maybe more interestingly now to this MiCA discussion, Germany introduced a custody license when it transposed the AML directive into German national law. And the reaction to the custody license has been mixed. In particular, it created insecurity in that space that uses decentralized technologies and various schemes where there may be where there is this sort of gray area between, well, is it still custody if it's a multi-sig scheme, is it still custody if special, trusted hardware modules are used to store private keys, and various kind of very technical, detailed questions have fallen prey to this generalized introduction of a custody license without much regard to the technical specificities of custody, what custody means in the crypto context. And you can certainly say that the handling of the introduction of that license didn't go very well. Most companies today that applied for a crypto custody license today still don't actually formally have it. They operate based on a grandfathering scheme. And some other irregularities are happening in that process, which are rather concerning. Now, on a more kind of brighter side, Germany has been introducing electronic securities in a dedicated kind of national regulation, paving the way in terms of some civil law regulations for issuing like debt or bonds as tokens on the blockchain. I would say it's this whole market of electronic securities is very early. It doesn't really it's not where generally the innovation has been happening for the past year or two. Let's just put it like that. So the impact of that regulation is yet to be seen. And I think now to close this off in terms of reviewing the German regulation, there was an attempt at defining guidelines on crypto taxation in Germany this year, which was perceived very negatively by the space. It's the complete opposite of the French approach. So the Germans say we tax everything, and we not only tax it, we actually increase the holding period on basically staked assets up from 1 year up to 10 years, which actually contradicts in a sense, the German national blockchain strategy goal of promoting sustainable consensus algorithms, where proof of stake would be one such consensus algorithm, but now staking is very unattractive in Germany to start with. And I think lastly, what was quite concerning in Germany is a draft implementation of the travel rule, which uses some very negative language around self-custodial wallets. However, self-custodial wallets are like the foundation for decentralized finance and many applications of the crypto asset, but generally blockchain technology, also when thinking of digital identities. So, and I think this, and now kind of tying this back into MiCA, also shows a little bit the German influence. I think the influence of the Ministry of Finance, in particular in Germany, on the MiCA regulation, which is all about, trying to let's put it like this, not recognizing at all the importance of privately issued stablecoins for Europe and for Germany, because this perception that just by going for a digital euro in 5 or 10 years would solve the problem, I think is wrong. We're already seeing in DeFi how stablecoins are an important settlement infrastructure, and it's most likely going to grow rapidly from there. And there is no significant digital representation of euro in any of those token schemes. And I think prioritizing that over anything else is actually an important strategic decision for Europe to take. And I think generally, I really have to agree with a lot of what Mark has said in terms of recognizing that what MiCA really does well, I think, is to provide a coherent set of rules for centralized use cases of crypto assets. But all the decentralized applications and use cases of crypto assets are currently not sufficiently recognized by MiCA and cannot, by how the rules are set up, be properly regulated in the scheme of the rules as they are set up. So we should really come together, recognize the importance of DeFi, stablecoins, and decentralized and open networks for Europe, and carve out a space for this to exist and be promoted in a dialogue with the regulators, with the legislators. That's it from me. Thank you.
Thank you so much. And it's been a valuable critique that you provided. I actually wonder how it's going to be translated from Germany to other countries across Europe. Not that anybody would be copy-pasting the regulation, it's just that usually it influences a lot, and for sure the influence of Germany on MiCA is pretty seen. Now that you mentioned that there is decentralization and that perhaps the regulation itself is more or less written for the centralized projects, I wonder, because it has been a question since day one, what does it actually mean to have decentralized project or a decentralized code? Those questions are still open. Same goes for DAOs, for example, what it means to be a decentralized and what it means to be autonomous, and what type of an organization are we even talking about? And when it comes to that, it really is us looking at the industry, asking all those developers, asking all those projects that are developing these solutions and talking to them, asking as many questions as possible to really understand the solutions better. And to my understanding, that is where EUTC, or European Crypto Initiative, actually comes into play. So I invite Mrs. Markezic to actually tell us more about what EUTC stands for. How did you came up with the idea? What were the beginnings of this organization, and what is it that you do today?
Thank you so much, Anya, and thank you so much for the organizers for organizing such a great event. We were just speaking before. I don't think something like this happened in the last few years in Slovenia, but I think this big conference can also be seen as a very, very important European conference. So we are very happy to be here on the last day, speaking about one of the most important, I would say, regulations in Europe regarding crypto assets. So everyone that is working in this industry will be affected by it. So not only the ones that are working in Europe, but also the ones that are interested in the European market. And I would also like to start just with a really short remark about how the Slovenian blockchain think tank, which Ms. Bla is also president of, has been discussing with the regulators in the last few years. We have been also one of the first ones, I would say very early on, to discuss with the regulators on tax issues with the Bank of Slovenia and other ones, and we could learn a lot from the whole process. And we have also seen that they have been very open to our suggestions. So learning from that and talking to my other colleagues, Simon Polo, from founder of the ADAN organization in France, and of course Florian Graz, from the founder of Bundesblock and the president of Bundesblock in Germany, we have been discussing this idea of talking or addressing the European issues together, but exactly a year ago, as it was discussed already today, we came together and we said we would need to come together, all these organizations, and speak to the regulators on the European level, because this is so much important for all the companies and the whole industry that we are representing. So this is how the European Crypto Initiative was born, and I think it was, at least for me, it was one of the most important things that I have done in the past. All of the founders of the European Crypto Initiative, we have been working in this industry at least for the last 5 years. We're all lawyers, so we have seen how the regulators have had different responses, how this was influencing the industry, and we also do very much understand what is happening in the industry and what are the trends. So I think it's sometimes we call ourselves translators, because many times we do talk to the, as Anya mentioned before, to the founders, to the developers with one language, and then we need to translate whatever they are saying to the lawyers and maybe regulators and vice versa. So this is actually our role, to represent the projects and the industry that is mainly open source, that is working on permissionless innovation, and also talk and educate different stakeholders on their principles, on their ideas, and what is actually the narrative of this industry. What is that they want to achieve, and what is how we can support this innovation that is happening. Today also was mentioned that more than 10 years ago the Bitcoin white paper was issued, and this is why we're all here. If this would not happen, we would not be here and we would not be talking about this regulation. And I think this is very important, because if we compare this technology to other technologies, I think it is very interesting, especially for us lawyers, to understand it better, because it's changing so much to what we have been used to before. And again, speaking about the process of how this regulation, but in general, legislation is adopted or designed, it is always done in a centralized way. And this is how it is, why it is so important for us, and why it is also really hard for us to understand why and how to regulate these decentralized technologies and decentralized use cases. And I think this is a very, I would say, interesting topic to discuss, but this is what we are very, very interested in and would like to contribute to the dialogue. So what we have been doing in the past year is talking to different stakeholders, regulators, different organizations all over Europe, and actually trying to present what are the trends and what is happening in the industry and how innovation really looks like. So it has been mentioned before that just in the last few months or in the last year, different trends like DeFi and NFTs has been growing a lot. So when I'm thinking about the draft and the MiCA draft, when it was thought about and when it was written, maybe DeFi was not that important and did not have such a big market. But right now, it is a very important part of the industry. So I think speaking again about the objectives that, again, we're mentioned today, I think that this innovation part is the one that we would like to see. I think Europe being one of the most important markets in the world, and at the same time being welcoming for projects that are willing to innovate in this space. And again, I think that what we really need to do is have discussions, educate ourselves more, and understand how this technology can help decentralized use cases, but again, also the whole digital industry and the digital finance. So again, very, very happy to be here, and I think this is a great event, and we're having really great discussions around this.
Thank you so much. Recognizing that I actually haven't asked Mr. Florian Gratz about EUTSI, do you actually do you have something to add on top of that? How do you guys cooperate together?
Well, thank you for the question. I think, well, first on UCI, so I think it needs, and we've seen that, funny enough, in the US, starting not only with Coin Center, which is a really great organization, but actually also now with certain DAOs allocating funds to research groups at Harvard, Harvard Law, or other kind of, grassroots organizations that try to create narratives and reach out to and fund efforts to talk to regulators, explain the innovation and the ethos, and I think also kind of the morals behind what a lot of those people pursue. I think UCI kind of falls into that type of innovation that we now see actually in the community. So we're very much a community-driven effort, but also I think a think tank that wants to propose very concrete regulatory proposals to make it really to bridge this gap, I think, as Marina adequately put it. I also just want to, because I didn't forgot to mention that before, kind of the reaction of the premature regulation, as I would call it, as we've seen it in Germany, if we can look at it as an example, is that just from a factual point of view, there is almost no significant company in the crypto asset space today, kind of in Germany with its corporate headquarters, with its assets, or its regulatory oversight. I mentioned that there is no euro-denominated stablecoins to speak of, certainly none in Germany. And I would say the massive talent pool that Germany started out with is slowly dissipating away to other jurisdictions that are on various levels more welcoming. And I think, and this is what kind of the bleak outlook would be if Europe wouldn't grasp the opportunities in the decentralized application of this technology. So I would say Germany today has virtually no stake or influence in any of the major developments in crypto. So we have Coinbase in the US, we have DeFi in various places, mostly US and Asia. We have various things, but there is, I wouldn't know what Germany now can particularly influence in this emerging industry. And I would really hope that Europe understands, and also learning from the past, right? Let's look at the internet. It's virtually the same thing. Let's just learn how we can be better in understanding how you actually exert influence on those developments that are bigger than you. And this whole crypto asset stuff, it's bigger than Europe. It's not like we can stop it. The question is, how can we exert the optimal influence so that we reach our goals? And we need to recognize that. And I think the decentralized applications of this technology is where the actual revolution is happening. And we're not recognizing that at the moment. And so maybe that could be a mission of UCI.
Does this work? Hello? Okay. So thank you for that comment at the end. I would just go through brief conclusion remarks, and if anybody wants to respond to what the panelists have been saying. I know Mr. Zwerc was making notes in between, so perhaps we can start with you. Do you have any comments on what we heard over the panel? What is your perspective now? Has your perspective changed on the MiCA? Are you taking into account the learnings that we are having from decentralized applications and projects that are working on this evolution? How do you see the whole thing?
Thank you. So I think that the main premise in this discussion was that this is not the regulatory framework to stifle the innovation, but it's actually enabling framework that would promote innovation. Because the companies, they like stability, they like predictability, they like legal certainty. And in addition, what the MiCA would give is the passport. So it means that if you register in one member state, you can provide services across the whole European Union, and you are supervised by the home member state in principle. So these are important for the companies, but at the same time, it also protects the investors, the consumers. It safeguards financial stability. There are also questions about monetary sovereignty, which are also attempted to be addressed here in the MiCA. So it's a win-win situation for the industry and for the consumers. And I think this is a very important message. I heard also lots of thoughts about decentralized finance that is developing. And indeed, this is the challenge to regulate, because the financial services legislation, the current state, it always regulates the intermediaries, whether these are banks or whether they are service providers. And the same is with MiCA. So it regulates the issuers and asset service providers. So where there is a system that is completely, fully decentralized, that there is no issuer, no service providers, it would likely fall outside of the scope of MiCA, and it would remain unregulated as currently it is. But the question again, another question, just to add is, normally it's also that this is a kind of marketing term, and so normally there is somebody behind the decentralized systems. So this is left to the member state national competent authorities to assess this, whether there is an issuer or service provider in this case.
Indeed, thank you for that. It's hardly ever going to be just a code, reacting and doing things on its own. It's probably going to be a human being behind it. So you mentioned that projects are looking for certainty on the market, and I can confirm that. Everybody's asking for certainty. Everybody's waiting for the regulation to be clear so that they know how to maneuver in this space. And indeed, when working with projects, usually what you hear is, yeah, we need that solution like yesterday. So turning to you, Clara, I would like to know, when do you expect this to be passed? Is there, any consensus or a general approach anytime soon, or what can we expect?
Yesterday. Yeah, it's due to the complicated process, nobody can predict the timeline. Since we are in the middle of the process, in the middle of the negotiations, we are trying to do our best as presidency. But at this stage, I'm not able to discuss the timeline.
Understood very much. And could you just explain what, if this passes in the time of our presidency, what does that actually mean for Slovenia?
When MiCA will be put into the force, the same effect will apply on all member states. Currently, crypto asset service providers will provide their services in compliance with the new regulation, as we suppose it will bring more protection to retail investors. Slovenia fully supports the changes, while we consider the retail investor protection vital for ensuring the stability of crypto market.
Thank you very much. About stability of the crypto, I know that there has been plenty of talks about the European markets, and I just wonder whether Mr. Banban has anything to discuss. I mean, now we heard a lot of perspectives from the US market, from the German perspective, from the EU market. What is your concluding remark? What would you say to the audience? What is it there to expect besides the reports from your organization?
Sure. Well, I think that, for the European legislative process, things happen in trilogue. My sense is that this legislation, given its importance, has actually moved relatively quickly. I think it's important that it does in terms of promoting regulatory predictability. From what I gather, I think some jurisdictions have felt it's moved too quickly. Others feel it's not quickly enough. But I think that having a comprehensive legislative framework, is it everything that the industry might want? You're always going to have challenges and things that could be improved. It's this process is compromise, but I think it's important to bring it to a conclusion. There will be further technical work where I think some of the technical questions may get addressed. But I think overall that there is a balance that's being struck between customer and investor protection and providing regulatory certainty. And I think having that regulatory certainty so that there can't be unpredictable or arbitrary changes is critical. I think around the world you still are seeing a lot of different approaches. And sometimes these have abrupt changes. Those are very destabilizing for individuals, for businesses, for companies that want to invest and put people. And so I think that Europe still has a chance to be a real leader in this area, and perhaps a leader to a greater extent than it was. I think it was pointed out that for the internet or Internet 1.0, or maybe even where it's been, but there's a lot of excitement over these types of assets and technologies. And you can sort of think about the internet as the internet of information, and blockchain and crypto assets are the internet of value and the ability to move things seamlessly, quickly, frictionlessly. So there's enormous economic potential and lots of huge benefits. So I think getting this regulatory framework in place, it may not solve everything. There are a couple of new innovations, NFTs and some of the growth of DeFi. in 2022 and 2023 and 2024, we'll probably start having, new vocabulary and further innovations. Hopefully this will provide a sufficient framework and that it's closed a lot of the gaps. So I'm optimistic that, through the compromise, but a lot of people's hard work, that this will have a very positive impact. And then the ability to passport, across jurisdictions within the union, with some, supervisory convergence, I think will be very, very powerful as well. And so I think there's a lot to feel positive about.
Thank you for that. And it looks as if Novi is going to be one of the words that we put in our vocabulary as well. So I'm going to be putting the stage to you, Mr. Worthington. Please do tell us, what are your concluding remarks? What are going to be the very next steps that you do with regard to consultation between the, all the member states, between all the regulators that in Europe we have? I mean, it's a pretty decentralized world when we talk about the regulators of Europe as well. It's not just a technological overview.
No, and thank you, thank you for the organizer, and it's great to hear from the esteemed panelists this afternoon. I think it's been a really good conversation. Look, I guess the thing that I've kind of like reflected on most actually is coming back a little bit to something that Mark mentioned about like providing the kind of like the space for innovation in the regulatory context, because I think a lot of what we've talked about today in the context of MiCA is about a specific regulatory framework with certain provisions, expectations, obligations, etc. But what we've not really talked about in the same degree is the regulatory tools available to supervisors. And, I think just this conversation has illuminated the challenge of almost drawing a line at a moment in time to say, this is the sector and how we're going to regulate it. But actually, as we're seeing, innovation happens at such speed in comparison to the legislative process. Do regulators have the right tools to provide that regulatory framework and certainty, but also allow for cutting edge innovation to be done so in a responsible manner? So I'd actually say my kind of like concluding remark is a bit broader than Mika, to talk about in that broader digital finance space, how do we better utilize tools and services like regulatory sandboxes to ensure that innovation can be done responsibly, across the EU. And that's kind of like what I'll leave my concluding remarks there.
Thank you so much. And I'm going to be mentioning again the analogy with the pilot, because one thing is to talk about whether the pilot has the capacity to actually drive that plane. The other thing is to talk about what plane are we actually talking about. Is it really just to, I mean, who knows? It might be an Airbus, it might be a spacecraft. So there are so many instruments, and it's hard to regulate all of them at once. Plus, the ecosystem changes so severely and so fast that we don't even know whether this regulation is going to be in place and effective, or is it going to be obsolete at the time of its emergence. So, any concluding remarks from you?
Thank you. Yes, I do have a few, and I want to widen the focus out beyond MiCA a little. At the moment, there's a huge amount of work going on in the Data Act, considering smart contracts, looking not just at smart contracts and their functionality, which is really, really important. In fact, I would say critical to tokenization, but also looking at data, provenance of data, who owns the data, where is it stored, can we trust it? And we've been talking this week about the convergence of AI and blockchain. Well, AI is nothing without data. I would put forward that blockchain is nothing without an application that moves data around either. So these wider contexts of how, through the Data Act, for example, smart contracts are being considered, the provenance of data, whether there are incentive models to share data across nations as well as really important topics like identity with IDAS, because that feeds into KYC and AML, which is another file that's super important and is traveling through the halls of Parliament and the Commission at the moment, or will be very shortly. And that then moves on to really important topics like privacy and GDPR. So given that gives you a flavor of the massive complexity, and by the way, all of our members in all of our work groups are working on these topics at the moment, you start to see how interconnected everything is. And something that Paul said just then resonated with me, which is given the task of experimenting and learning across all of these complex areas is frankly so enormous, it surely makes sense for the private and public sector to work together in perhaps a construct like a sandbox or some other name for an experimental area where we can go on that learning journey together. And what we're seeing finally on the global stage is that this giant puzzle is being tackled from different perspectives by different geographies. As Jeff alluded to, in the US, it's coming with the infrastructure bill, arguably from a collection perspective, maybe from a tax perspective. In Africa, it's coming firmly from an innovation perspective. In the Middle East, it's coming from a transitionary perspective, a move from a dependency on fossil fuels to a more service-based economy. And as we look to China, one could argue it's coming entirely from a governmental perspective. So I don't think we're going to see a lot of global agreements at this point in time. And I think this is why Europe has a window of opportunity here to see if it can work with an industry that's as innovative as a blockchain industry, gather information, go on a knowledge-sharing journey, and maybe reinvent the printing press for the modern age, redemocratize finance, and do all of the other good things that blockchain has the power to do. But the gift is in the hands of those in power. So the question I ask us all and the audience is, and this goes to a certain extent to Rock, are you listening?
Thank you, Mr. Taverner. It's actually been great talking to you, and I am mindful of the time, but there's also a question from the audience, and it goes back to what you just mentioned, the sandboxing, and perhaps even connected to who the global regulator really is. Is it really the states, or perhaps the global regulators have already changed their faces? So to turn into the question of our audience, does the Commission or any member state plan to create sandboxes as spaces for innovation without the extreme regulatory burdens? So that has been a question that has been around for 5 years, maybe even more, and we've heard of some of the states. So the floor is open to all the panelists, whomever wants to answer the question, but perhaps Marina, Florian, you have any concluding remarks that could also answer and address the question from the audience?
Yeah, I can jump in. So MiCA is quite far in the process, but I heard rumors that there may be room for something like this. So I don't think it's impossible. I actually think it's inevitable. The question is really just how quickly we get to that point. I hope we can get there fast, that we can draft this sandbox regime, like the DLT regime in a sense, right? But for an actual market where there's actual stuff happening and people are innovating, right? So I think if we get there fast, we may have a chance to do something great. So I think we're all for it, and I'm hopeful that we'll get there. Thank you.
Thank you so much for that. And maybe just the final remarks from Ms. Markiewicz. How does one contact EUC, or how does one do anything with you? What are your next steps?
Thank you for the question. What I wanted to just briefly mention at the end is trying to look at whatever we are discussing today from a perspective of a startup. So it's an innovative team, a small team that wants to have great ideas, but then of course they need to have a clarity on the regulation. And I do agree today, again, it was mentioned before that clarity is very important, but at the same time, those startups that work in the blockchain industry, they are global by definition. So they want, and also the technology is global by definition. And it also comes from a generation of founders that were born and that were using internet very early, and they are using social media. What I'm saying is, why can I have a company or innovate in the same way as I'm using social media? So to be present everywhere. And that might be a dream. I think that we need to find a balance between this kind of really innovative ideas and, of course, all the other objectives of MiCA, but also putting it into perspective linked to maybe some other markets that are very important in this industry. And this is also what we want to do and what we are doing, trying to support innovation, but also support dialogue and to learn from each other. So we're open to any suggestions or collaborations. As mentioned before, we have been in the last year discussing with the regulators, but also writing white papers and studying all these new provisions. So I think it's going to be a very interesting year ahead.
Indeed, it is going to be very interesting. Unfortunately, our time is up. I can see that there is additional question about the NFTs, the non-fungible tokens, if MiCA, for example, applies to them or not, and I would love that question to be addressed as well. But perhaps all the panelists can just leave their contacts in the Zoom chat, and perhaps you can also share your contacts with us, especially with your organizations as well, and we can address all these questions in a private time or after the panel. But so far, I just want to thank all the panelists. It's been incredible. You have brought a lot of clarity, and I do look forward to more interesting discussions that we're going to have with you.